Welcome to Cocktail Copter Explainer, where we are looking at how have courts pronounced themselves on matters. Article 37. How does the law in the Constitution, Article 37, that gives the right to demonstrate, to picket, but must be peaceable? These questions have been raised severally to court. In the previous episode, we gave you the Public Order Act. Here, we are telling you the questions as they are and what the courts have pronounced themselves. In the High Court at Nairobi, Judicial Review Application number E082 of 2024, Justice Nga Judge gave a judgment in December 31st, 2024. In this matter, Kenya Human Rights Commission, Katiba Institute, Kenya section of the International Commission of Jurists, Transparency International Kenya, Institute of Social Accountability, African Center for Open Governance, Siasa Place, Tribeless Youth, Muslims for Human Rights, and sued Japheth Koome Chebere. That was the Commissioner of Police then in his person. Interested parties: the Law Society of Kenya, the Kenya Medical Practitioner, Pharmacists and Dentist Union, the Kenya Union of Clinical Officers. The issue in this matter is that the Kenya Medical Practitioners declared a peaceful demonstration pursuant to Article 37. They said they will go to demonstrate on the streets of Nairobi. They gave notice to the Inspector General of Police. The Inspector General of Police said there cannot be demonstrations. So what did the judge find? Does the Inspector General of Police have the power to stop demonstrations? We have seen similar speech by the current Inspector General of Police, the Inspector General of Police, Kanja, flanked by his two deputies, the DIG Police Services, Lagat, the DIG AP Services, Masengeli, plus the DCI, plus all the commanders, and they have said the demonstrations are not going to be allowed. Just the same as the ones KMPDU said. What did the judge make out of it? He said, a prohibition order is hereby issued restraining the Inspector General of the National Police Service or any other officer subordinate to him from enforcing the respondent's decision of 4th April 2025 purporting to suspend Article 35, Article 36, 37, and 41 of the Constitution by cancelling KMPDU's members' right to strike and to picket peacefully and unarmed. So the court found out that any proclamation by the Inspector General suspending a strike is equivalent like suspending Article 36, 37, and 41 of the Constitution, which the Inspector General does not have that power. So the demonstrations cannot be stopped because the Inspector General has said they have refused. Number two, the order of certiorari is hereby granted, removing to this honorable court for purposes of being quashed the response decision dated 14th April 2024 purporting to suspend Articles 36, 37, and 41 of the Constitution by cancelling KMPDU members' right to strike and to picket peacefully and unarmed. For the avoidance of doubt, that the decision is hereby quashed. That decision was quashed. So anybody trying to say that the demonstrations are illegal is a waste of time. 3. A declaration is made that Under Article 238, 239 free, and 245 2B, and Sections 8, 8A, and 10.4 of the National Police Service Act, Cap 84, the Inspector General of National Police Service is accountable and personally liable for the acts or omissions of officers under his command infringing on the rights of the individuals under Article 36, 37, 41 of the Constitution. So, if anybody is injured in these demonstrations, if anybody his property is destroyed, if any police officer who is under the command of the Inspector General of Police goes ahead to clobber, to tear gas, to throw anything, to chase, to throw what is called the tear gas on the protesters, the Inspector General will be held liable. It says, in particular, if anybody issues unconstitutional orders and directives to officers under his command to use unlawful force to disperse peaceable and unarmed strikes, assemble, protest, and picket under Article 35, 36, 37, and 41, or abdicating effective control of police officers under his command by failing to investigate and discipline those officers who violate this Constitution by using unlawful force to disperse peaceable and unarmed strikes, assemblies, protests, and pickets contrary to Article 37 of the Constitution. These were orders dated and signed and uploaded on the CTS on the 31st December 2024 by Judge Jairus Nga. In petition E009 of 2024, that is Saitabao Ole Kanchori, petitioner, and the Inspector General of Police, Cabinet Secretary, Minister of Interior and National Administration, the Attorney General, Independent Policing Oversight Authority, Interested Party, the Law Society of Kenya, and the National Commission on Human Rights, Justice Mugure Thandi, gave the following as her decision. In the end, and after foregoing analysis, the following orders commend themselves to the court. A declaration is hereby issued that the use of water cannons, tear gas, live ammunition, and rubber bullets, and the deployment of brute force or any form of violence against persons exercising their constitutional rights to protest against the finance bill is illegal, unconstitutional, and acceptable in an open and democratic society. The judge is saying the police cannot use water cannons. It cannot use tear gas. It cannot use live ammunition and rubber bullets. And they must not use any brute force. And the judge proceeds to say, a declaration is being issued that the extrajudicial killings, arrests, abductions, detention, harassment, intimidation, torture, cruel, inhuman, and degrading treatments of persons exercising their constitutional right to protest against the finance bill is a gross violation of the Constitution. The judge is endorsing Article 37. The police can't arrest, they can't disperse, they can't use tear gas, they can't use any force, they can't kidnap. That is the decision of Justice Thandi. Whether it can work, whether this judgment can work, we leave it to court helicopter views. Will the police sell all the tear gas vehicles that they have? Will the police return all the rubber bullets? What will the police use if the demonstrators go berserk? That is the decision in the final part of this. In the case of Justice Makau, Justice Makau has responded appropriately to Justice Thande. Mine is to bring you what the law is. In the final decision that gives the right to the demonstrators to demonstrate, it was petition number E373 of 2024 before Justice Bahati Mumuye. This is a very recent decision coming in April 30th, 2025. This was a petition where the Law Society of Kenya went to court against Martin Mbaye Kidinji, Isaiah Ndumba Murangiri, Moses Mutai Shikuku, Adamson Bungei, Inspector General of Police, Attorney General, and Katiba Institute, and Kenya Commission of Human Rights. What are the orders of the judge? The judge said, a declaration be and is hereby issued that the proposed limitation of the rights to exercise Article 37 in the subject area was blanket, omnibus, and overly broad one, and thus it did not meet. He goes on to say, a prohibition order in C, this is very critical, a prohibition order be and is hereby issued restraining any police officer or any other person acting under the direction, control, or in support of the National Police Service from taking any action to obscure their identification. They are not supposed to hide their identification, registration, or markings of any motor vehicle being used when in any way dealing with the persons who are planning to assemble to demonstrate. Justice Mwamuye is saying the police must use police Land Rovers with GK number plates. The DCI must use their Subarus with police number plates. 2, all police officers must wear uniform, plus including the NIC officers, the intelligence officers, the DCI, they must wear that. 3rd, every police officer must have an order, a name tag placed on his lapel. This one, the judge got it right, because in schedule, 6th schedule, which we read in the first episode of the National Police Service Act, the 6th schedule 10 says a police officer in uniform shall at all times affix a name tag or identifiable service number in a clearly visible part of the uniform. So the judge went and looked at the National Police Service Schedule 6 and said the police in dispersing the demonstrations must wear in uniform. 3 judges. We have Justice Mugure Thande, Justice Nga, and Justice Bahati Mwamuye agreeing that this is a fundamental issue. It cannot be stopped. Again, we have Justice, the next Justice Makau, saying you cannot have rights without obligations and accountability. Hear what Justice Makau says in the dissenting opinion. Different, not in any court sitting together, not in a 3-bench judge, but in a 3-bench judge, but in his own view. In case number 2, we have the Constitutional and Human Rights Division, petition number 269 of 2016. This is Ngujiri Wambugu, petitioner against the Inspector General of Police, the Cabinet Secretary, Minister of Interior and National Coordination, and the Honorable Attorney General. What were the orders of the judge? The facts are the same. Stopping the demonstrations from going on. I find the petition to be meritorious and proceed to order as follows. 1. a declaration be and is hereby issued to the effect that the fundamental right under Article 37 of the Constitution of Kenya to assemble, to demonstrate, to picket, and to present petitions to public authorities is conditional on the protesters or demonstrators conducting themselves peacefully and unarmed, and that police officers working under the Inspector General of Police have a duty to immediately stop protesters or demonstrators if they are armed with any form of weapons, including stones or any offensive weapon or whatsoever. So, if you are on demonstrations and you are armed, you are carrying stones, you are a goon armed with crude weapons, the Inspector General has the power to arrest you and disperse that meeting. This is the High Court saying in Wambugu case. So if you are armed to go destroy people's property, if you think you are going to burn people's cars, court helicopter tells you, if you are like that, the Inspector General has power to stop that demonstration and tear gas you to preserve life and protect the property of other people. 2, a declaration be and is be issued to the effect that the petitioner and non-demonstrators, third parties, enjoy equal rights and freedoms during demonstrations, since their rights and fundamental freedoms are not suspended during each time. Third parties who will be working, employees who will be going to work, owners of business have a right also to enjoy their freedoms. So don't think that you have a right to trample on rights of others. This is a clear message to the Gen Z. This is a clear message to the millennia, and this is a clear message to the organizers that nobody will be allowed to demonstrate with an intent to rob, with an intent to mug, with an intent to destroy property, with an intent to destroy the peace and order. Third, an order be and is hereby issued directing the respondents to formulate or amend the requisite law and regulations to ensure that demonstrations are peaceful and held as per the Constitution, including inter alia prescriptions for demarcation of demonstration zones, responsibilities for cleanups, maximum numbers, consents of persons and entities adjacent to demonstration zones, with appropriate penalties when they go outside the expectations of the law. This is very, very critical. The judge is saying the conveners, Kalonzo Musyoka, if he's the convener, Rigiji, if he's the convener, Wamalwa, if he's the convener, Natembeya, if he's the convener, Matiang'i, if he's the convener, Sifuna, if he's the convener, Babuyao, whoever are organizing. It is their responsibility to ensure no property is destroyed. And if that property is destroyed, they are liable for that. There cannot be the law of the jungle applicable when the country is there. Lastly, an order be and is hereby issued directing the respondents to formulate a code of conduct for conveners of demonstrations that include detailed explanations on how they intend to ensure non-demonstrators are not adversely affected by such demonstrations, and that provide a clear line of responsibility of who is liable in case of loss of life or property or for injury when a member of the public is aggrieved by that demonstration. The judge has pushed the definition of Article 37 that the conveners and those going for demonstrations must behave in a manner that property and life is destroyed. Equally, the judge has told the IG, the Attorney General and Parliament to make laws to create zones for demonstrations, to create routes and streets for demonstrations. It can't be left to go like that. I know many will not agree with me, but that is the law. And that law of Justice Makau is still law in this country. It has not been appealed. It is the final kick from court helicopter telling you, be accountable for your actions. Don't go destroying people's property. For the young boys, don't be hired with 50 shillings. It is your right to show displeasure. It is your right to show how uncomfortable you are about the prices of petrol, but you must be accountable. Lastly, has this question ever gone to the Supreme Court? Yes, but in a different situation. There were demonstrators before this country gained the 10th constitution, the current constitution. These are people who are fighting to get the freedom we came to get in 2010 under the new constitution. Under section 74 of the old constitution, there were people called Koiwa Omwere. Have you heard of Koiwa Omwere? The freedom fighters. They were detained. The Raila Odinga, Baba, he was detained. These people went to the Constitutional Court. This is a case called Petition number 26 of 2019. Monica Wangu Wamwere, Priscilla Mwara Kimani, Lucy Waturi Kimani, Esther Gadoni Gishimu, Michael Maina Kamani, and Koigi Wainaina versus the Attorney General. They said they were beaten, they were brutalized, they were hurt, and the Supreme Court awarded them this. The government of Kenya shall pay damages assessed at Kenya shillings 2.5 million shillings each to each of the appellants in this consolidated appeal. So the freedom fighters were given 2.5 million. In other matters, there were those women who were demonstrating and picket and removing their clothes at Uhuru Park. They went to the Supreme Court. They were awarded damages of 3 million shillings each. Can the family of Raila Odinga move to court for compensation? Yes, they can go to court. Okili, Dan Sanumari, getting to you the different sides of the coin. Keep watching as we exercise Article 37 fairly and constitutionally. Thank you.